vestiges of the right of property and the comment thereon. Though the mass of citizens shall no longer have any guaranteed right of to compensation of his property in acquired or requisition, and the legislature shall have the no constitutional obligation to provide for payment of any solatium to the expropriated owner. Two exceptions in the general position are allowed by the 44th Amendment in two cases of acquisition. If the property acquired belongs to the education institute established and administered by a minority, the law of acquisition must provide for such compensation as would not abrogate the right of minority to establish and administrative education institution, which is the guarantee of Article 31 shown by Anu Inu, in, Enunodo. This means that the state choose the acquired minority educational institute. It must be full market value and adequate compensation so the minority community may have the institution and suitable alternative site. If the state seeks to acquire the land which is the personally cultivated by the owner and such land does not exceed the statute ceiling, the state must pay such owner full market value of land as well as building or structure standing there on the appurtenant thereto. Though both the foregoing exceptions may be beneficial so far as they go, there is much to comment from the standpoint of constitutional law and from the national standpoint. As regard the concession in favor of minority educational institute, it is somewhat inexplicable why the guarantee should be made in favor of educational institute managed by the member of majority community. It is not education as the pure and adorable, whether it comes through the Gangas or the Jordan. In over the zealousness on the addition of a special guarantee in the favor of minority with the father of original constitution did not envisage in father of the 44th Amendment took the time ponder that the eliminated Article 31(2) they were taking away right which had been guaranteed to all persons in India. Legally speaking, new provision of Article 31A is a tale which has lost its head of repeal Article 31(2). As the right of a small tiller of the land to full compensation for this land when building or other structure, one fails to understanding why the similar right should be guaranteed to a poorer man who has not an inch of agricultural land but has a humble hut to lay his head at the night. He may be day laborer, a petty pensioner, or a landless peasant who tills another man's land. Are they less deserving? Would is not be pertinent to point out the context that even of 1977 Constitution of the USSR there are the Article 30 which is the state. The personal property of citizen USSR may be include article of everyday use, personal consumption and convenience, the implement and they are the object of small holding or the building of individual dwelling, personal property citizen and the right of inherent in the protected by the state. In short, in the USSR, every individual had the guaranteed right to hold and inherit the dwelling, irrespective of the being the agriculturist. Duty of the state to protect the right would be obviously mean the state cannot be acquired the deprive owner a dwelling house unless otherwise provided by the constitution. The overzealous political leaders in India should know that the provision in the 1982 Constitution of the Chinese Republic too. The overzealous political leader of India should now the provision in 1982 Constitution of Chinese Republic to the same strength. Though the Article 6 is provision the social ownership of the means of production, Article 13 at the same time guaranteed to the individual to own personal property acquired by the personal income. The state protect the right of citizen is own lawfully earned income, saving house and other lawful property. Article 39 further that declare as a fundamental rights that the citizen homes are unavoidable. In the net result of foregoing provision seems to be the state cannot be take away an individual dwelling house and similar personal property even by the legislation so that the no question of compensation of compulsory acquisition may be arise. In the view of drastic effect of the evolution of Article 19(1)(f) and 31(2), some jurists in India have put forth their belief that the Supreme Court would come to rescue of the expropriated owner by holding the notwithstanding the omission of such constitutional guaranteed right to compensation. The court would derive such right from the legislative power contained the entry 42 list of third acquisition and relinquishing of the property, requisition of the property. Read the common law doctrine of eminent domain. Unfortunately, it had been possible for the author of persuade him to the anachronistic assumption for reasons which have been elaborately given to author the bigger works. In these circumstances, there is the case of restoration in some relief for the poorer section of the property owner, as distinguished from the capitalist or owners of the mean of production. Why such relief can be more easily brought about the a further amendment of the constitution yet one the constitution then living is to co offenses of chances of the judicial amendment. Article 32 constitutional remedies for enforcement of fundamental right. Article 32 constitutional remedies for the enforcement of fundamental rights. Abstract declaration of the fundamental rights in the constitution are useless unless there is the no means to make the effective. Constitutional experience of all countries shows that the reality of existence of such rights is tested only in courts. The power of the courts to enforce obedience to the fundamental rights again depends upon only the impartiality and dependence of the judiciary, but also upon the effectiveness of the instrument available to it to compel such the obedience against the executive or any other authority. Under the Anglo-American system, such means have been found in the writ of judicial processes such the habeas corpus, mandamus, prohibition, certiorari, and quo warranto. The Indian Constitution lays down the following provision for the enforcement of the fundamental rights guaranteed by the Constitution in the light of above experience. The fundamental rights are guaranteed by the Constitution not only against the action of the executive but also against that the legislature. Any act of executive or legislative would have which takes away or abridges any of these rights shall be avoided, and the courts are empowered to declare it is avoidable. Article 13 Supreme Court strikes at the arbitrary action of the state. It has jurisdiction to enforce fundamental rights against the private bodies and the individual and award compensation of the violation of the fundamental rights. It can exercise the jurisdiction suo motu or the basis of PIL. Apart from the power to treat a law to avoid or being contravention of the provision of constitutional guarantee of the fundamental rights, the judiciary has been armed with the power to issue the writ of mention above the habeas corpus etc. in order that the enforce such the right against the authority in the state for instance individual whose right have been violated. The power to issue these writs of enforcement of fundamental rights to given constitution to the Supreme Court, High Court, Article 32 and 2 to 6. The right of guaranteed shall not be suspended except during the proclamation of emergency in manner of laid down the Constitution, Article 359. Special feature the jurisdiction of Supreme Court under Article 32. Special feature of jurisdiction of Supreme Court, Article 32. Though the fundamental right may be enforced by other proceedings such as the declaratory suit under the ordinary law or application under Article 2 to 6 or way of the defense to legal proceeding brought against the individual. A proceeding under Article 32 describes the Constitution as a constitutional remedy for the enforcement of the fundamental right included in part of third, and the right to bring such the proceeding before the Supreme Court itself a fundamental right, a part third. Article 32 thus the cornerstone of the entire edifice set up by the Constitution. Commenting on the article, the Constitution is that if I ask the name any particular article of the Constitution as the most important, an article without which this Constitution would be a nullity, I would not refer to any other article except this one. It is very soul of the Constitution and the very heart of it. The relevant provision of clause 1 and 2 article 32 should be noticed. The right to move the Supreme Court appropriate proceeding for the enforcement of right conferred by the part of guaranteed. The Supreme Court shall be power issue direction or the order or writ including writ of nature, habeas corpus, mandamus, provision, quo warranto, and seriously, whichever may be appropriate for the enforcement of any of right conferred by the it. Article 32 thus provide a guaranteed remedy for the fundamental enforcement of these rights, and this remedial right is itself made a fundamental right, being included in Part 3rd. The Supreme Court is thus constituted by the protector and guarantor of the fundamental rights, and they cannot consistently with the responsibility so laid upon refuse to entertain applications seeking the protection against the infringement of such right on technical grounds. Thus, though the writ may be ordinarily confused on the ground of the petitioner has another adequate legal remedy upon him. A application under Article 32 cannot be refused merely on the ground of where the fundamental rights appear to have been infringed. The Supreme Court can make any order appropriate to the circumstances unfitted by the technicalities of English prerogative writs. On the other object, sole object of Article 32 enforcement of the fundamental rights guaranteed by the Constitution with whatever other remedies may be open to a person aggrieved. He has no right to complain under Article 32 where the fundamental rights has been infringed. So some reason, no question other than the relating to a fundamental rights will be determined the proceedings under the Article 32. Prerogative writs. The expression of prerogative writs is one of the English common law which is referred to a extraordinary writ granted by the sovereign as a fountain of justice on the ground of inadequacy of ordinary legal remedies in course. Time these writs come to issued by high courts of justice as the agency through which the sovereign exercised by the judicial power. These prerogative writs are issued extraordinary remedies in cases where there was either no remedy available under the ordinary law of the remedy available adequate. These writs are habeas corpus, mandamus, provision, seriously, quo warranto. In a sense of power of the high courts in issue these the writs of wider than the Supreme Court, which in so much as under Article 32 Constitution Supreme Court has the power to issue these the writs only the purpose of enforcement of the fundamental rights varies under Article 2 to 6. Differences between the jurisdiction of the Supreme Court and High Courts to issue writs. A High Courts can issue these writs not only the purpose of enforcement of fundamental rights but also the redress of the other injury of legality owning the contravention of the ordinary law, provided certain the condition were satisfied. Note which see chapter 20. Thus, application to a High Court under the Article 2 to 6 will lay not only where the fundamental rights has been infringed but also where the some other limitation imposed by the Constitution outside the Part 3 has been violated, where a state legislature imposed the said tax in contravention of the limitation of imposed by Article 286, but the application under Article 32 shall be not lay upon the case unless right infringe the fundamental right enumerated Part 3 of Constitution. Another point of distinction between the two jurisdictions is that while the Supreme Court can issue a writ against any person or government within the territory of India, a High Court can under Article 2 to 6 issue a writ against any person, government or other authority only in such person, government or the authority physically resident located within the territorial jurisdiction on the High Court within the state which the territorial jurisdiction of the particular High Court extent or cause of action arises within such jurisdiction. As stated earlier, the Supreme Court has been assigned by the Constitution a special role, the protector and guarantor of the fundamental right. By Article 32, in the appropriate case, when the court feels that is the investigation by the police authority is not a proper direction and in order to do complete justice in the case where the high police officials are involved in the crime, it is always open to the court to hand over the investigation to the independent agency like CBI. In order to invoke the jurisdiction Article 32, approach the Supreme Court directly. It has to be shown as why the High Court had not been approached, could not be approached, or is futile to approach to High Court. Invocation jurisdiction by the Supreme Court under Article 32 of the Constitution cannot be said appropriate where the direction from was given the production of minor child was to illegally removed to the India by his mother from his foreign country, and the child was traced through the CBI on the writ petition filed by father who is foreign citizen.